we are today persuading researchers. When you are doing your proposals, have a budget line indicating, just like you list workshops, conferences, travel. But we could all then, by the way, I said that my role today is to provoke you. So don't take offense. If we were to IP protection for any,
Thank you very much, Prof. and Mr. Anum, for your answers. Let me start from a very minor point, and that has to do with when you started, and the topic was commercialization for enhanced IPR management in the CSIR. I turned it around, I said enhanced IPR management for commercialization in the CSIR. And that helped me follow through your presentation and got me to be asking these questions. In fact, I will limit myself to only two. The first has to do with the question of how you can succeed as somebody managing the technology transfer office to manage the intellectual property of the various divisions or departments or institutes within the university or the research institution. And so when you talked about you being able to set up the technology transfer office in your university, I thought maybe you can share some experiences with me and then I'll learn. So that's the first thing. The second has to do with the intellectual property system generally. And if you take the case of patents, you've secured your patents, you have been able, but it's not just an issue of just having funding to patents or to secure your intellectual property. It also has to do with the financial resources to do your monitoring. I would want your comments on that as well. Thank you.
Yeah, like I did indicate, you look at where your prime markets are. And there are certain times, I remember one instance was a case of HIV drugs for Ghana, where Ghana invoked the clause for compulsory license, which meant that Ghana could have that produced, and we would then pay the owner of the right. Now they made an assessment and said the Ghanaian market was too small, so it came free to Ghana. So it's not all infringements that you would want to attack. You will look at the market size. How is it, what is the dent that might have cost you? So it's not every infringement that you go after. It has to, does it make commercial sense, etc. So there are some markets that you would seek for protection, but it's just for strategic purposes. So unless we have a specific case to deal with, then we can look at the issues. But usually, you want to engage a legal firm and can be quite expensive. So you need to look at what you are losing and then do your what you call your net present value issues, and then you
True, I started the technology transfer office that later collapsed. And this office was started 2003, just 1 year before we launched the IPO policy. At that time, just 3 years before, the government had come up with a policy that indicated that much of the government funding for the education sector would go to basic education, and that tertiary institutions needed to find ways of generating income to supplement government efforts. So we started two major programs. The first program was called Parallel Degree Program, which was mainly to open up for those students who could sponsor themselves to access university education, apart from those that were sponsored by the government. So therefore, in the university at that time, you could get two types of students, all but in the same class, others sponsored by the government and others self-sponsored. So that was one income generation stream. The second income generation stream that we had was how to generate income based on the knowledge that is available within the universities. So we are talking about technology transfer, we are talking about consultancies, we are talking about making available laboratories for SMEs to come and use and pay. And we realized that, those activities needed to be coordinated in a commercially oriented manner. And we thought that a technology transfer office would do that. In fact, in my university, we even went ahead and said that technology transfer office was not good enough because it would be like a unit of the university. So we established a company called Mo University Holdings Limited, which was company limited by guarantee, so 100% owned by the university. And the mandate was to generate money. And 5 years down the line, we did not generate adequate money to get recognition, and the governing council of the university said that no, this entity was a drain to the university than bringing in money. So it was closed. Two things happened 5 years later. One is that it was reestablished because the university realized that they were now losing on the other very, very important aspect, and that is the third mission of the university, which is to make knowledge available for development. But two is that before it was closed, it acquired a government-owned company, which was collapsing, a textile company. And today, the university is proud to be the only university in the region which is having a fully fledged textile company called Rivertex, fully owned by the university. And by the way, interestingly enough, the university is the second leading in terms of IP application in the country, because the bulk of them are coming from this company. So I just thought I should be able to mention it. It backs up what I was saying earlier, that the mission why you are establishing it must be very clear. Income generation is important, and definitely it will come. And note I'm using the word, it will come. Patience is required, Chairman, to support technology transfer office until that level that you feel they can be on their own. The benefit is enormous, but might not be seen by many people who are just looking at the technology transfer office from the financial lens.
Thank you, Prof.
Okay, thank you very much. My concern is about how long the intellectual property will last. What I know is it varies from one country to another country. And in some other jurisdictions, even within the provinces, within the same country, we still have a variation. And that's my concern. I haven't taken a look at the policy yet, but if you can clarify a bit on that. Thank you.
Well, I think that was the case some time back. But currently, most legislations across the globe are using the minimum standards from the TRIPS agreement, the trade aspects of intellectual property. So that sets the minimum standards for IP protection. So now there's more of convergence. So for example, for patents, it's 20 years. But that is on paper. It states that 20 years, but you need to renew it annually. Now, it also, although it says 20 years, it also depends on the industry in which you find yourself in. So, for example, if it's electronics, within 2 years, that has become obsolete. So, although it says 20 years, commercially, will you hold something that is not commercially viable for 20 years? Then when you come to trademarks, it's 10 years, but you can renew it endlessly. But there's a condition there. It should not become a household name. So if your trademark becomes, for example, I think sometimes, you know, you have this photocopying machine, and which was known as Xerox. Some time ago, yes, Xerox nearly became synonymous to photocopy, and they had to fight it back. If they didn't fight it back, it would have lost that trademark. But you can continuously, renew it every 10 years. Then when you come to industrial designs, our regime here used to have it for 15 years. Now, with the new act that we have, it's for 25 years. For geographical indications, as long as you keep the quality of the product is endless. So currently, you won't have, I don't know which jurisdiction is practicing that, but if they are members of the WTO and they've signed on to the TRIPS agreement, they have to, I think, that making your laws compliant with TRIPS, I think, began somewhere in the early 2000s. So currently, you should not have, I can't vouch for every country, but most countries have gone for the TRIPS minimum standard.